Welcome to the Legal Advice in Paradise podcast, brought to you by www.legaladviceinparadise.com. Even in one of the most beautiful places in the world, life can be litigious. On this podcast, the best and brightest legal minds gather to help you navigate your way through every legal question you may face. This program will help you know your rights, know what steps to take, and help you find the best legal representation, all in simple, easy to understand terms. And now, here's your host, Justine Gronwald.
Aloha everyone, this is Justine of Legal Advice in Paradise, and we are here with Martin Hsia, if I said that correctly again.
Close enough.
Close enough for part 2. And of course, if you listen to his part 1, he is an attorney that specializes in trademarks, copyrights, intellectual property, and all that good stuff. Mm-hmm. You went into detail kind of in the basics of what you cover.
Right.
So in the second part, what we want to address is if someone were to come to Martin for the first time, what exactly does Martin is going to require of you? Say you came up with a bright idea, or like me, a podcast, an invention, or just anything. What are the basics that Martin's going to want from you instead of just sitting in front of him, just blank? And so I'm going to give that to you. So somebody calls you up, you set up a time for them to come and consult. Mm-hmm. What exactly do you want them to bring with them?
Well, first to check, because I don't give free initial consultations.
Oh, okay.
And there's a real good reason for that. Everybody's inventive, and
Mm-hmm.
many times people who come in with an invention, they say, oh, wow, this is a great invention, and I want to get a patent on it. And then they decide that they're not going to use me. And then later on, another person comes in, and this has happened to me several times, with exactly the same invention. Exactly the same invention. And then they have me file a patent application for that. Mm-hmm. And then if that invention ends up on the marketplace, mm-hmm. then the first person says, hey, they both hired Martin. We both hired Martin, or talked to Martin. Mm-hmm. And so Martin must have disclosed it to the second guy. And then I get sued. So I do not want someone's secrets in my head unless they're a paying client.
That's for your protection.
That's for my protection.
Yes.
And also your protection too, because the fewer people who know your invention, the better it is. Because in most countries, in many countries, you must apply for a patent before the invention is disclosed to the public anywhere in the world. The United States is not quite like that, but it's fairly close to that. Mm-hmm. So it's very, very important if you're dealing with an invention that you keep it secret. So the first thing that you come in and you're dealing with an invention, mm-hmm. the first thing I'll want is, number one, I want a 1 or 2 page description of what the invention is in writing with a drawing so that I can quickly understand what you're trying to invent. And I'd like to know, among those things, what is making your invention different from what went before. Mm-hmm. Because as I said in the previous episode, everything can be described as a combination of A, B, C, D. And what you are coming up with as an invention is element X. And so I need to know what A, B, C, D is, and then I need to know what your element X is.
Now, do you require, if they have a prototype or a mock-up?
I don't need to have a prototype or a mock-up.
You don't need any of that. You just need that description,
right.
1 2 page. Oh,
right.
Okay.
The U.S. Patent and Trademark Office does not require prototypes. If you're dealing with a predictable technology, that would be the general and mechanical and electrical technologies, they don't even require you to do anything more than just describe what the invention is, because those are predictable technologies.
Okay.
When you're dealing with chemistry or with biochemistry, pharmaceuticals, then you have a much different situation, because there you have an unpredictable technology, and they probably will require working examples and other information to prove that it actually works. Mm-hmm. And if you have certain categories of inventions, they will definitely need proof that it actually works. So for example, a perpetual motion machine, they will require proof that it actually works. Mm-hmm. It used to be that other kinds of things were not patentable subject matter, and now they are. For example, it used to be cures for baldness. They would not accept patent applications on that. But now I think we've heard of Rogaine. Yeah, because it was something they did not think would ever happen.
Wow.
So if you do have an invention, most times you're not going to have the problem of running into these unusual kinds of areas where there's no patentable subject matter.
But there is that area of pioneers where something like, you never know, and then wow.
Right. And so we deal with pioneering inventions a lot of the time. Typically what I'll tell a client is, I need to know whether your invention is something that is going to generate enough money to justify the attorney's fees. And if the client hasn't thought about that, then I'm wasting their money and my time, because 95% of all patents do not earn back the money it took to get them. And so I try to point that out to clients. It's against my self-interest. I make money if you file a patent application, but my job is not to make money for myself. It's to act in the best interest of the client. And so if the client believes that there is an invention that is worthwhile, we need to go through the pricing structure. We need to see how much people would pay extra for this feature X. What's the additional cost for the feature X? How many units can you sell? How much do you profit per unit? And then once you've made that determination, then you can proceed. Now, I have patented inventions that are industry disruptive and worth millions and millions of dollars. Very often, those inventions fail.
Wow.
Not because of a problem with the invention, but because of a problem with the business execution.
Oh,
So it's really, really important to realize that a lot of the time, you may have an invention that's worth millions and millions of dollars, but the problem isn't in the patenting or getting the invention. The problem is in the business execution.
And now, business execution, we're going to go off a little bit here. Does that mean the marketing of the...
Marketing,
Because
or
that's, you got to get the word out.
yeah,
I
or
mean-
not inability to get investors.
Oh, okay.
And so you need to think very carefully about how you're going to do the business execution. And so when you're dealing with patents, those are the kinds of things that I look for at the first interview. I'm always glad when someone who comes in at first interview on a patents is already in the industry. Because if they're already in the industry, they know what's out there, they know what the problems are, and they know how the industry is likely to react to this particular technology.
Now, is that one of your qualifications, that they're not a newbie? That when they call you up, said, "Have you done this before?"
No, it's not my qualification.
Okay,
No.
I was just wondering because, it could be. It sounds like it's hard to. It's like you got to educate that person.
Yeah.
I mean, that's what we're kind of doing right here, right now. Right.
Sometimes people come in who are not in the industry and they see a solution to the problem which was never occurred to people in the industry. Because when you're in the industry, you're too close to it. So
Always.
Yeah. So that's why when you're coming in and sitting down, I want to know what's being done in that particular industry, and what is your feature X, and is that feature X worthwhile spending the time and money on a patent application for. Then you need to think about two major things with feature X. One is feature X new? Has someone else done it? And that means has somebody else invented it, maybe in a foreign country, and published a master's thesis on it in a non-English language.
Wow.
Because that can be cited against you as saying, hey, this is something that's already been invented. So you need to know whether it's new. But that's not enough. The most important thing is, and this is what I spend most of my time fighting with patent examiners on, is feature X non-obvious from the prior art? That is, does it give you something that's more than just ordinary innovation? Does it give you something that's unpredictably better, unexpectedly better?
Can you give us an example that everybody knows about, or
This is
something that's not a trade secret? It's already out there.
This is something that's the U.S. Supreme Court case, and you can go to Google and look at this case. It's called KSR versus Teleflex, Teleflex, KSR v. Teleflex. Just go to Google and look at that case. KSR versus Teleflex held that a patent was invalid because it was relating to an electronic accelerator linkage between an accelerator pedal and the engine of the car. And what the patent was, it covered the electronic linkage to substitute for the mechanical linkage. And the Supreme Court said, well, there's nothing here that gave you unexpectedly better results. All you did was end up with the predictable result of the expected result of the combination of components. So if all you're achieving is the expected result of the combination of components of your invention, if A, B, C, D, X only achieves what you would expect from A, B, C, D, X, because X is already known from some other industry, for example, then A, B, C, D, X is not going to be patentable over the prior art of A, B, C, D. A, B, C, D is already known. We call it the prior art because it's the state of the art. A, B, C, D is in the state of the art. How do we know what the state of the art is? By what went before. That's why we call it the prior art.
What works.
Yeah. So you know what the state of the art is from the prior art. And the prior art is every patent publication throughout the whole world. Public usages in the United States, plus public usages in foreign countries. And every country, by the way, has this concept of prior art. So you need to know what's in the prior art. And what the examiner is going to look at is, here's your invention, A, B, C, D, and you're saying feature X, A, B, C, D, X is what you're trying to get a patent on. The examiner is going to look and see, do I see A, B, C, D somewhere? And do I find X somewhere? And if the examiner can find A, B, C, D somewhere and X somewhere else, then the examiner is going to say, well, it would have been obvious to combine A, B, C, D, X to achieve your desired result. And so what you need to do is tell the examiner, no, you would not have had someone deciding to take A, B, C, D and then modify it by adding X because of these particular reasons. And so after KSR versus Teleflex was decided, the U.S. Patent and Trademark Office came out with examining guidelines for its examiners and various examples of how you determine whether something met the requirements. And almost all of those examples said you have to have unpredictably better results, something unexpected.
Is that the trade secret right there?
No, this is all public record. Everything in patents is public record until the patent application is secret until it's actually published. It's published 18 months after filing. By the way, these are the recent changes in patent law, and they've come about over the last 4 years or so. So that's why, well, actually, that publication has been from like 2001, but there are all kinds of major changes that have happened in patent law. So you need to be aware of these major changes because they may affect what you want to do. So what I tell clients is, if you've got something you want to keep secret, you can't put it in a patent application. The patent application is going to be published. Even if the patent is denied, it will become public knowledge, and everyone in the world can see it.
Wow.
So you need to be very careful when you're applying for a patent. The other thing about patents...
You have to be at a certain... you want to get all your stuff together prior to filing for a patent.
A patent application must also contain what's called an enabling disclosure. It must teach someone of ordinary skill in the art how to make and use the invention. So, for example, I'd like to file a patent for an anti-gravity machine.
Ooh, that would be cool.
But
astronaut stuff.
But I cannot get a patent on an anti-gravity machine because I can't teach someone how to make and use it. Until I teach someone how to make and use an anti-gravity machine, I cannot get a patent on it. A patent is not something you can get on a desired result. You have to show how to make and use whatever it is that you're trying to patent. And if you don't have that, then you don't get the patent. So when you're coming in, if you've got a mechanical and electrical invention, my background is physics, so I can cover a fair number of broad technologies.
You said
right.
Physics.
Right. So I can cover a broad range of technologies. If you're going to do pharmaceuticals, other issues arise relating to pharmaceuticals. FDA, you need to have the Food and Drug Administration clearance.
Let me ask you this. Here in Hawaii, what is the most that you see that people come to you with? Are there inventions to make life better in general, like the new gadget as seen on TV type stuff, or what you see in infomercials? What's the most?
I've seen all kinds of technologies, all kinds of inventions.
So in Hawaii, we have a lot of people who are very creative.
Yeah. I've done patents relating to, for example, a basaltic termite barrier that was obtained for the University of Hawaii that's used to stop ground termites. And then I obtained patents on medical imaging devices, surfing devices, hula dolls, all kinds of other kinds of things. Some of the patents that I've obtained money on, huge amounts of money on for our clients, have related to, for example, biotechnology kinds of things, where methods for culturing or preserving foods, for example, that have been widely adopted.
Yeah.
So what I call it is industry disruptive technologies that disrupt an entire industry, that are adopted widely, quickly by an industry. And then you have a big problem, because the people in the industry, they need to have this and they don't want to pay the royalties. And so when you have a technology such as that, an industry disruptive technology, you have political problems because the R&D departments, the research and development departments of the people that are in that industry, they don't want to admit, oh, well, we didn't come up with that. And then you've got a big problem, because all the competitors in the industry all of a sudden see you have a huge competitive advantage because the marketplace wants to buy your product instead. So they will go to and say, let's copy this or do something that's variation. And that's when you need to look at your patent and see, does my patent cover all the variations?
And that's where you come in, because when you started correctly in the beginning, it sounds like even though you're going to spend a lot of time and a chunk of money, it's worth doing it.
What I tell clients is this. You come into my office and you say, I want to protect this. Okay, I can do you a patent application that protects only what you showed me. That's cheap. But that's not going to get you what you want. Because you don't get a patent to cover what you want to do. you get a patent to cover what your competitor wants to do after he's seen what you've done.
Oh, I see.
And see how valuable it is. Mm-hmm. And then they're trying to figure, well, can I change something to avoid the scope of this patent? And the other point that's really, really important is you cannot get a patent that a court will not issue an injunction to stop an infringer unless and until you can prove that you are suffering irreparable harm, harm that cannot be cured by the payment of money. And that's true of patents and copyrights and possibly of trademarks, depending. So it's very, very important that you realize that these kinds of rights, a court might not enforce them by issuing an injunction and may instead just say, okay, the infringer can continue to infringe, they just have to pay you damages.
Oh.
So you need to be aware of these aspects as well.
Yeah, and that's not your long-term goal, just to get paid for damages. You want this thing to go to fruition.
Yeah, you either want to get a lump sum payment, or you want to get a string of royalty payments.
So when they sit with you, they have the description. It's a 1-2 page. You go over it with like.
I want to know what variations there are that they want to cover. And the cost of a patent application will vary depending on the technology. If it's a simple mechanical device, it's not that expensive. If it's going to be something that's a high-tech kind of device with a lot of variations, which are really, really important, then it's going to be much more expensive. So it will all vary depending on the kind of technology, whether it's a pioneering invention that is completely different from what anyone else ever did, or whether it's a minor improvement. The other aspect is that if you only protect the way it looks, that's a lot cheaper. That's a design patent application. That's for an ornamental design for a manufactured article. So, for example, if this microphone here were shaped in the shape of a bird and still functioned, that's an ornamental design for a manufactured article, and we could get a design patent application on that.
Well, they do have one called the Blue Nessie, and the reason why it looks like it's got the neck like the thing.
You can get design patent applications on these things. Jewelry, for example, the necklace you're wearing might be subject to a design patent. So those are a lot cheaper. They're still expensive because most of the money actually has to be paid to having a draftsman prepare the drawings. But design patent applications are much cheaper and faster to get than a utility patent application. So when a client walks in, I say, do you want to protect the way it works or the way it looks?
And what if they say, I want everything?
If you want everything, then we have to see, because a design patent application only protects the way it looks. And so someone can change the appearance, have it function the same way, you have no protection because it looks different. If you want to protect the way it works, then that's a utility patent application, much more expensive. And then very often, in that circumstance where they say, I want to protect everything, I'll say, okay, then what we do is we file utility patent application and a design patent application. And by the way, if the way it looks is really, really, really important to its saleability, I file a trademark application for it as well.
Because, so you cover all the bases.
Yeah. And then there's a possibility that it might be copyrightable subject matter. It depends, because industrial designs usually are not copyrightable subject matter. But maybe there's a possibility of copyrightable subject matter as well. And I guess I should mention this other thing. Hawaii is different from most states on the mainland, because in the smaller cities on the mainland, people will practice both patents and trademarks. But when you're dealing with the mega firms on the mainland, they split patent attorneys into 4 different species. They cover by technology. There's going to be the general and mechanical, the electrical, the chemical, and the biotech patent attorneys. And they typically will not be doing copyrights and trademarks or other aspects of intellectual property laws like we have to here, because we're a small city.
Right.
But we handle all of those areas, both U.S., foreign, and international. And I've been practicing law long enough that I've been doing a lot of internet stuff too. I was doing internet uniform domain name disputes arbitrations before we had the Uniform Domain Resolution Procedure.
And how long ago was that?
1990 something
or
other.
Oh gosh, that's pioneering stuff.
I mean, I've lived through the PC revolution and the internet revolution, and now we're going through Internet 2.0.
Wow.
So
I can't even imagine what it's like in cyberspace with intellectual property. It's just like the Wild West.
Cyberspace is the Wild West.
Yes.
There is no law in cyberspace.
Yeah.
So that's one problem. When you have someone who's infringing on your rights in cyberspace by putting up a website, for example, you have no recourse against them unless that you can get a court to do something, and you know which country they're in, and the court will enforce your rights in that country. So that's why you can get recourse if they've stolen your domain name. Okay. Because then under domain names, you can say, I've got this trademark registration. Another reason for getting a trademark registration.
Yes.
I've got this U.S. trademark registration for this brand, and they've taken this and they have stolen it and used it as their domain name. And that's why I tell people, go ahead and register all the domain name variants at the beginning to avoid having to do this.
Right.
And then what you can do with that trademark registration is you can go through what's called a UDRP proceeding, do an arbitration, so that you can stop people and get that domain name away from them. But that doesn't stop you from, or doesn't help you if someone who's not in the United States decides to put up infringing copyrightable subject matter. If they're not in the United States, a U.S. court's not going to take jurisdiction over them. If you're dealing with someone who's in the United States, very often they will respond to a DMCA, Digital Millennium Copyright Act, takedown notice saying, this is copyrightable subject matter, I own the copyright rights, take it down. Then what will happen is it typically is taken down within 10 days, and then the person who posts it can decide, I'm going to challenge that and respond to the DMCA takedown notice, then they'll put it back up, and then you can file a lawsuit. So there are these kinds of procedures that are available in cyberspace, but when you're dealing with cyberspace, you have to be aware of the fact that if you're dealing with someone who's in a foreign country and is not subject, you don't have any rights in that foreign country, you've got a big problem. So it is the Wild West in cyberspace. My personal view is that cyberspace, the internet, has basically made it impossible for anyone who deals with digitizable subject matter, digitizable content, to make a living. And it's very sad because I play music, and composers and performers are no longer getting paid money and cannot make a living because people just steal everything. And so that is very sad, because less and less music and less novels and books and movies because people are not being paid. But that's how technology has evolved. And until the law gets changed, that's how it's going to be evolving in the future.
I'm glad you touched on that part. So somebody sits in front of you, they've gone through the detail, you're giving them all the different scopes as far as what they should be covered. Do you also recommend or refer other attorneys to, like you said, if you want to have it under the estate planning, do you refer out
I'm in a general practice law firm. So a couple of days ago, we have somebody who came in, and unfortunately her spouse had passed away, and he was a very prominent musician, so had to have someone from our estate planning department come in and advise with respect to certain aspects of it. Got another client where similar kind of situation. It was the son who's the client, actually their company, and it's a question of ownership of various brand names, and so we had to look at the estate planning documents and figure out what happened and deal with those aspects. There may be tax issues that come about because depending on your circumstances, you might be able to get capital gains treatment for some of the investments you're making in your patents. There'll certainly be corporate or other kinds of business law aspects, so my corporate department will help in creating the limited liability company or corporations, especially if you're structuring it for takeover.
So you don't have to go outside of CADES SCHUTTE.
No.
You have it like all in-house. They come to you and you can refer to others that specialize in that area.
You hire our firm, you've got everyone in the firm.
Wow.
And so that
all in one, folks.
All in one. So we cover every area of practice except possibly family law. And I've been involved in family law cases where I work as co-counsel because the marital estate included, for example, a New York Times bestseller.
Oh, okay, that makes sense.
Yeah. And then we've also handled, we don't handle criminal law, but we have handled some white-collar criminal stuff. And so we cover basically everything that a business would need.
Fantastic.
So, it's helpful to clients to have everything in one place. That's what we found. But it's something where if you talk to me about the intellectual property aspects, hopefully I'll recognize some of the issues. When someone comes in and they come to me with these inventions or other creations they have, I will need to have other information such as the estate planning and where you want it held, because
so
the ownership interest is really important.
Okay, so that's one thing. If they come in and they have estate planning, you want to examine that as well.
I don't necessarily need to examine it. I just need to know who you want to own it, because when you're dealing with these kinds of rights, who owns it? It's a very interesting question.
So,
because
if you have an existing estate planning, you can have it amended, amended to include.
Actually, no. What we would do is, if you have an existing estate plan that created a revocable living trust, for example, then what we would do is we would prepare the documents necessary to transfer your rights into that revocable living trust.
Okay.
But the fundamental issues that you have when you walk in are also who owns the rights, because if you created an invention and you were an employee at the time, and your boss had told you, hey, I need you to create this. It may be that the company owns the patent rights and not you. Similarly, if you are a member of a union and there was a collective bargaining agreement that said all the inventions belong to the union or a company, if you're hired by a company, a well-advised company will have you sign a document that says anything you create when you are working for the company belong to the company.
Okay.
So the Post-it note, which has made 3M Company millions and millions and millions of dollars, it was created by an employee. And so I'm sure he got a nice Christmas bonus, but I don't know that he made any money from it.
Wow, that's interesting. I didn't know that.
Right. That's
I thought it was an inventor that did it and 3M bought it. That's what I thought.
No.
But it was somebody they employed who figured it out, and
usually
what a bonus for them.
Right. Usually when you're working for a company and the company is well advised, then that company will have you sign a document, or it'll be part of the employee manual, saying that the inventions that you come up with that are related to the company's business interests belong to the company.
I see. So that's something that everybody needs to be aware of. Like, I can see how that would have issues, but if you know beforehand that I'm going to give all this, time and effort toward that, you got to know that it's not yours.
Right. The other thing that's really fundamentally important, especially for people in the creative arts, if you hire an independent contractor, that independent contractor owns the copyright rights, not you. Now, luckily, you're a blogger and you're doing everything yourself. But let's say that you had hired a friend to be a videographer. That friend would own the copyright rights to the video.
Okay.
It's under a U.S. Supreme Court case called Community for Creative Nonviolence versus Reed. In other words, if you are aware that independent contractors own the copyright rights to their own work, you can always fix that by having them sign a contract, sign an agreement after it's been created, to transfer the copyright rights to you.
I see. Because if it's an employee, it's different. But if you hire outside freelance, then it's their...
Freelancers own the copyright rights to their own work.
Wow, I didn't know that.
Right.
So if I hired... Okay, we're doing this off of my laptop, a webcam. If I had hired a videographer to do this, then you're saying that it would be his...
Yes.
Unless we had signed a contract prior.
Well, no, you can't do it by signing a contract prior. I know a lot of people think you can. Actually, for this particular case, you can, because the copyright statute does allow an audiovisual work to be made a work made for hire by a written contract.
Okay, made for
However,
hire.
But if this were something else other than, let's say it was a sound recording only, and you had a recording engineer, that recording engineer may have put in enough copyrightable content, copyrightable contribution, he may have, that it would create a copyright rights. It's easier to see if it's music. Let's say you hired a musician to play along as the soundtrack, and then to add that. The musician owned the copyright rights to whatever he created.
Wow, okay.
And then if you wanted to own those copyright rights, you have to have them transferred to you. Again, it would not be audio-visual. It'd have to be audio only. And the reason why I'm so certain about this is because someone had changed the Copyright Act to add sound recordings. There are 9 special categories of works that can be created, can be made work made for hire by a written contract, and only those 9. Well, someone added sound recordings in a technical amendment to the Copyright Act, some congressional staffer probably, and Congress was very upset about that. The next session immediately canceled that and immediately passed a law that said that has no effect whatsoever. So those 9 categories of work that can be made copyrightable subject matter by a contract are only those 9. And audiovisual works, test material, atlas, answer material for a test, supplements, forwards, that kind of thing. And sound recordings are not those. And so Congress means it. You cannot make it into a work made for hire unless it's one of those 9 categories of work.
Well, I know that a lot of listeners out there are musicians.
Right.
And I think particularly in Hawaii, we have a lot of gifted people here who are trying to get into the industry, and then thinking, let's just get a gang together and we'll have this guy do this and this guy do that, and nothing is thought of in the beginning. Right. If they were to sit with you, you would say, well, you guys are all chummy now. Yeah. But later on, when it's like who's is what and all that stuff, it could get kind of sticky.
I actually had a case like that where we had a small group that actually made it onto a mainland film and part of the soundtrack. It was a very prominent film. The problem was that they hired a manager, and the manager decided that he was going to try to do XYZ with people, and it screwed up everything, and so they ended up failing as a group because the group fell apart because of the manager. I've had 2 instances actually where the wrong manager came in and tried to manage the performing group. I'm a musician, so I understand some of the issues here.
I come from a musical background. My brother had his own group.
Right.
And I have friends out there that are into music.
Right.
So, and everybody's dream is to record.
You need to think about these things. I represent some recording companies as well, but I also have to point out what Miles Davis said. My favorite musician, Miles Davis, he said, "Man, those lawyers come in and ruin everything." So you got to be careful about that. You need to find a lawyer. If you're a musician, you need to find a lawyer who A, plays music, B, has been doing it a long time.
And that's you, Martin.
And the reason why I say you have to find someone who knows it a long time, we have 3 different versions of the Copyright Act. And the oldest version is from the 1978. Well, December 31, 1977 and before, we had the 1909 Copyright Act.
1909?
Yes, the 1909 Copyright Act until 1977, December 31, 1977. From January 1, 1978 until, March 16, 1989, I think we had the decennial version. And then from that period on till now, we have the Berne Convention era. And if you don't know the laws of the pre-1978 copyright, you have big problems. And people don't know this unless they've been practicing law, because anyone who graduated law school in the 90s or the 2000s, they haven't really had to deal with the questions of issues of pre-1978 copyright law. I have. And my teacher of copyright was Dorothy Schrader, who was in-house counsel at the Copyright Office at the time. And at that time, we had just adopted and had just come into effect the 1978 Copyright Act. And so we were dealing with those fundamental questions at that time. So if you're dealing with somebody with copyright, you better have somebody with a lot of gray hair, because they won't have the experience or knowledge otherwise to even spot the issue, because they'll just assume, oh, it's just the same as the existing copyright law, completely different.
This is good, because a lot of the attorneys I've been talking to, in fact, all of them say, don't just settle on the first attorney that you talk to. You need to talk to them at length and know that they can handle what you want. So this is right along that lines. Just because you're going to go Google it or whatever, and you say, oh, this guy is intellectual property and all that, I'm just going to call him, go with them.
Every attorney says they do intellectual property. If you talk to somebody and says they say they do intellectual property, ask them, how many federal trademark registrations are you counsel for?
Okay, this is important. Why don't you go through that, and how many, go through the questions that people should ask attorneys prior to hiring them for this kind of case. Okay, go ahead.
How many patents have you obtained? In how many countries? Have any of your patents been in court? Have they been enforced in court? How many trademarks have you done? And in how many countries? For copyright, it's not so bad, but you want to find out, how long have you been practicing copyright law? Was it before 1970? Was it before? Are you familiar with pre-1978 copyrights?
Okay.
And if you're dealing with licensing, are you familiar with licenses? Have you done patent and copyright licenses? Just get an idea of what they do. Every attorney is going to say they know intellectual property law.
Really?
Ask them whether they do patent law. And if they say yes, ask them, what's your registration number? Mine's 32471.
You have to have a registration
You have to be
number?
Okay, it's very difficult to become a patent attorney because of the requirements.
Okay.
Number one, to be a patent attorney, you have to have an engineering, chemistry, or physics degree, or otherwise show that you have the technical qualifications.
Wow.
Most lawyers don't have such a degree. My degree's in physics. Number two, you have to take the patent bar exam. And when I took the patent bar exam, the pass rate was 39%.
That's low.
It is no shame to say you had to take the patent bar exam twice because you failed the first part, or one of the parts. There are 2 parts to it. This is back when I was taking the patent bar exam in the 80s.
Wow.
Number 3, you have to be an attorney at law. 3 years of law school, pass the patent bar, and then pass the, in this case, the Hawaii bar exam. If you have not done all 3 of those things, you are not a patent attorney. So there are very few patent attorneys around, and that's why people say, well, I'm an intellectual property attorney, because then they can avoid the question of whether they're a patent attorney. Because if you're not a patent attorney, you can't advise clients on how they can lose their patent rights, how they can gain their patent rights. You cannot file a patent application. I have an associate at my firm who's also a patent attorney, and so ask them, what's going to happen if you're out of town or whatever? Do you have somebody who can back you up? We have 2 patent attorneys on staff.
Wow. Okay.
So we can handle, and we have a litigation department that has litigated patents, trademarks, copyrights.
That's good.
Not just in U.S. federal court here in Hawaii, but at the Trademark Trial and Appeal Board, the Patent Board of Patent Appeals and Interferences in Washington, D.C. We've done these things. So if someone says, oh, we can do intellectual property law for you, ask them these questions.
Okay, good. I'm glad this came up. You know?
It's something where I don't go out there and spend a ton of time in marketing because hiring an attorney is a very personal kind of relationship. And you need to get along with your attorney. You need to have comfort that your attorney is trustworthy. And so it's something where I try to give that information. I give out as much information as I can that's generally applicable so that people understand what to look for. Even though it's against my self-interest, because I make more money if you file a patent application, I'm trying to show people the business side.
That's good.
But it's something where I also cannot let people tell me all their inventions because I'm working on other inventions all the time, and it might be one of theirs. So we represent everybody from individual inventors to large companies. We represent, for example, some of the large car manufacturers and some of the large entertainment companies in things when they have them in Hawaii, for example. So we have the ability to handle just about everything related to intellectual property. I don't do my own litigation because otherwise I'd have to drop all my other clients when a big case came in.
And you have someone for that.
I have 2 litigation partners who've litigated patents and trademarks and copyrights. So we have the capability to handle almost everything, and we have a whole litigation department that can handle any huge case that comes in if necessary. We have several other attorneys who have been brought into some of these cases and have experience in patent litigation as well, or trademark litigation. So we can handle these things. It's just a question of a client needs to know that the attorney they're dealing with is qualified and experienced.
Right, and this is all the attorneys that I've talked to say exactly the same as you.
Right, because every attorney will say, yes, we can do this.
Yeah.
But when you ask the nitty-gritty questions, well...
I think that's the important. I think it's the nitty-gritty. Yeah. It's not just the... And you gave some really, really detailed questions of what people should ask.
Right.
Yeah,
so if you come in here with, for example, a creative product, you say, I'm going to start a record label. 1, what's the brand you want? Now, to see whether it's available. Number 2, do you have recording contracts? Oh, well, we want you to draft them. Okay, who's going to own the copyright rights? The recording contract specify, and the same thing for a book publisher. Do you want the copyright rights to be owned by the book publishing company, or the recording company, or the authors, or the composers, or the musicians? And then how are we going to be dealing with issues such as, oh, well, we're bringing in this other musician, and we're going to use one of his compositions.
Oh.
That creates all kinds of issues. That you need a mechanical license for. Or we're going to be licensing this out to somebody who wants to put in a movie. Well, you need to do a synchronization license. Are you guys going to be members of ASCAP or BMI? Are you going to be dealing with Harry Fox Agency? All of these kinds of issues. There's a whole existing infrastructure of music that most people in Hawaii don't have any idea about.
You're just saying all these things. I'm like, what?
Yeah.
What about if someone writes a book and people have, contributed to it?
You have a big problem there because there's an interesting question as to whether it constitutes enough of a contribution that they have to be named as a co-author.
And in order to be co-author, then
it's a question. There's an actual case where there was a composer and a lyricist who worked together to create a song. The music publisher did not like the lyrics, I think it was, and changed and hired somebody else, and somebody else wrote the lyrics, and then they published a song. And it was determined to be joint work between the composer and the second lyricist because it was intended that the work be a joint work. West Side Story, I think most people are familiar with it.
Oh, yes.
West Side Story was Leonard Bernstein wrote the music, Jerome Robbins did the choreography and contributed on the libretto, if I remember correctly, and Stephen Sondheim did the lyrics. So who owns the music to West Side Story? It's not Leonard Bernstein. It was a jointly created work. So all three of them have a 1/3 interest, undivided interest in West Side Story. Leonard Bernstein therefore has a potential 1/3 interest in, for example, the choreography or the libretto. It was a jointly authored work. It was intended to be jointly authored work. So copyright rights and all kinds of other intellectual property rights are not intuitive. For example, there are many myths out there that people think, and many attorneys who don't deal in this area think they're true. Oh, well, to preserve your invention rights, just write down the invention and put it in an envelope and mail it off to yourself. That's dead wrong.
I never heard of that.
Well, a lot of people think that that's right. No, dead wrong.
Wow.
Mailing an invention to yourself will not establish a date of invention. It's not something that's worthwhile.
That doesn't sound right anyway to me.
Other people say, oh, well, you can change something 10%. No, you can't. There's no rule that you can change something 10%. So there are all these rules of thumb that they're myths that are out there about intellectual property. And so what you need to do is deal with somebody who does this day in and day out. I've been doing intellectual property, patents, trademarks, copyrights, trade secrets, day in and day out since the 1980s, 100%. So if you have somebody who has that much experience, then go with them.
Yeah.
I don't think there's anyone with that much experience in Hawaii.
Yeah.
So I think that I've seen almost everything there is out there.
Fantastic.
So it's something where, from your point of view of, there's no substitute for experience.
No.
And so if someone comes to me their first time, I'm going to ask them these questions.
Okay.
And the fundamental question is, this is about business. You're not doing patents, trademarks, copyrights just because you want a certificate to hang on the wall. Well, maybe you do, and then I'll put it on the wall for you. I'll get it if you really want to, but as long as you understand, it's only to get a certificate on the wall. You get these rights because of two reasons. One is the ability to protect your business against somebody who's going to steal your innovations, your inventions, because you have a business or you're creating a business and you want to be able to protect those innovations. The other is because you want to have a portfolio of rights that will attract investors or that you can use as evidence to for someone to buy your business. But again, patents, trademarks, copyrights, trade secrets, they're all about business. Don't get emotionally involved.
I think like a lot of people, we're so close to it that we do get emotional.
Right. But you have to make your decisions based on cold-hearted business judgment. And if you look at it, the invention and say, it's not going to make money, then drop it. Because you need to move on with your life, use your time more wisely doing something else.
I heard Kevin on Shark Tank say that to several people, and it's the cold hard facts, but it's our baby, right?
It's your baby.
Someone's business or whatever is their baby, and they just can't see that, and sometimes you just got to be the voice to tell them,
and your attorney
to save them a lot of time and money. And
your attorney has to be somebody who will be honest enough with you to tell you that, rather than somebody who says, I need to make money from you, and encourages you to do X, Y, and Z.
Well, I'm glad that you're ethical that way, and you have a heart. I think that's the most important thing in this world.
I've been an inventor. I've been an inventor. I've also been a client of attorneys several times.
Yeah.
So
you've been on both sides.
I've been on both sides.
That's
so
great.
I know what it's like, and I know what stress it is to go through a lawsuit. So it's something where...
Me too. I went through my own.
Right. So for that reason, you need to have somebody who has experience and knowledge, and also who has somebody's backup in case they're out of town. I was out for 10 days in Hong Kong attending the International Trademark Association meeting, for example. But you want to have somebody with the ability to take care of your needs. And it's not just intellectual property you'll have needs for, because what I do will affect all kinds of areas of your life, like estate planning.
That's what I'm discovering
and
today.
Business. So that's why you need to be with a firm that has the capability to cover everything that you need.
And I think you did that beautifully, and we're perfect on this part too. I think this is so much, this is priceless. I want to thank you so much.
Oh, you're welcome.
And I have to give a shout out to Peter Carlisle, because I asked Peter, do you know a good intellectual property? He said, okay, I'll look into it, and here you are. So
thank you, Peter, for the referral.
And we want to say thank you so much for tuning in. I know a lot of the audience is probably, like me, didn't know a smidgen of this thing, and now we're armed with a lot of things, because there's a lot of creative people out there.
And there are a lot of scam artists out there. Do not use LegalZoom. Do not use the
I think a lot of people
inventors'
do
kits.
that. I think a lot of people do that.
I have never seen a trademark application being done by somebody else who's not a practicing trademark attorney that was done correctly. And there are many, many major problems you have in trademark applications. It looks very simple to do a trademark application or a copyright application. It's very simple. It's very simple to do wrong. And you will find that out when you come in to see me if you want to, go ahead and use LegalZoom and then hire me. And then I'll be able to tell you why there are problems.
Okay.
Okay.
Well, thank you so much, Martin.
Okay, thank you.
That was incredible, and we're going to say aloha, and see you in the next episodes.
Thank you for listening to the Legal Advice in Paradise podcast. For more information, visit www.legaladviceinparadise.com.